So now that I went over negligence, here is another way to categorize the negligence rules that I just taught you. Is what I just taught you would be defined as ordinary negligence, and another definition would be ordinary negligence as a result of an accountant's act or failure to act given a duty to act. So the next level of negligence would be a specific set of conduct that entails a false representation of a material fact, but in this case, this misrepresentation is conducted on the part of the CPA when they don't necessarily know that it's a false representation, but it is intended to induce reliance. Whereas the next category, fraud, which would be intentional misrepresentation, is deemed by a court of law as being even so egregious that it goes beyond just negligence. So the third type of negligence is gross negligence. So this happens with very specific circumstances in which an accountant acts in such a way where they don't even employ any level of care at all. So let's say that they are employed by a client to file their taxes and they just don't do it at all. That would entail gross negligence. Pretty straightforward. So the intentional misrepresentation that I mentioned before on the slide when I talked about negligent misrepresentation is called fraud. So this would be categorized beyond even just negligence and looks at the intent of the defendant when they conduct a willful and deceitful act. In this case, if the accountant is found liable for fraud, then not only will the plaintiff get reimbursed in damages for the losses that they suffered, but punitive, which is a punishment, and compensatory damages could also occur. So if a plaintiff succeeds in a court of law on the basis of fraud against an accountant, then they would have to prove these 5 elements. So these 5 elements include: the accountant made a misrepresentation. The misrepresentation was made with scienter, that is, with actual knowledge of the fraud. The misrepresentation was of a material fact. The misrepresentation induced reliance. And another person justifiably relied on the misstatement to his or her detriment. So what the first element refers to as a misrepresentation is simply that the defendant made a statement or employed conduct that was not actually true. So this would be telling the plaintiff that perhaps they had extensive experience in a specific area of tax law, and that the accountant said so with knowledge that they did not have expertise in that area of tax law, and then the actual understanding or belief that the accountant was qualified in that area actually led to the plaintiff suffering losses as a result of that knowledge or belief, and we would call this reliance. And the reliance has to be justifiable, so it has to be something that a reasonable person in a similar situation would have also relied on. So the last 2 areas the first of the last two areas that I'll be covering is privileged communication and confidentiality. So we'll be looking at the accountant-client privilege. In this case, we'll look at federal law and we'll see if an accountant-client privilege exists in federal law. And federal law doesn't actually recognize a broad privilege of confidentiality in this case. This is distinguished from the attorney-client privilege, which does exist on the federal level. For the accountant-client privilege, that privilege does not actually exist nationally, but it does exist when it comes to tax advice. So what is the accountant-client privilege? The accountant-client privilege is simply that any statements or documents that come from a discussion between an accountant and somebody who is paying the accountant for, in this case, a client, their communications cannot actually be used as evidence in a court of law. So the confidentiality privilege does apply federally when it comes to tax advice. And we went over this in class 1 when we talked about practitioners and qualified individuals that are allowed to practice under federal law before the IRS. So that's when, in the federal side, the accountant-client privilege exists. On the state law side, it's actually in existence, but only in a few minority jurisdictions. So with New York, it actually does not exist. So this protection would not be valid in the state of New York. In the states where the privilege does exist, then it always belongs to the client. So if there were a lawsuit in which privileged communications are allowed between a client and an accountant, and it's recognized by that state, the privileged information must be brought, or the claim that information is privileged must be brought by the client, and it cannot be brought by the accountant. So the accountant cannot be the one to say, hey, you can't use that communication. It has to be the client. What's important to note here too is that if the client discloses the communication contents to a third party, then they cannot bring that privilege up in court as a bar for evidence. Lastly, looking at the working papers rule, which states, working papers are confidential records of an accountant's performance of an engagement. These working papers document the procedures performed, evidence obtained, and conclusions reached. So this refers to pretty much the work product of an accountant when they're providing financial services for a client. And all of this, these working papers are the property of the accountant. So because these working papers are prepared by the accountant themselves, they generally provide the best evidence of the accountant's performance. And these working papers usually cannot be accessed by third parties without at least a court order or client consent. But they can be subpoenaed by a third party for use in litigation in the states that don't recognize the privilege of accountant-client communications. And lastly, working papers may be disclosed to another CPA partner of the accounting firm of that CPA without the client's consent, because usually that information isn't even communicated to outsiders and it's internal. So that concludes part 2 of our lecture for class number 3, and I'll see you next time.